This is Nicholas Economides, Florida attorney with offices in Clearwater. Today I'm going to discuss with you a relatively complicated topic, and that is the difference between suing a corporation or a limited liability company for damages directly or indirectly. The distinction is important. The verbiage that is used to describe indirect actions against corporations or limited liability companies that we really need to focus on is derivative actions. So you can bring a direct action or an indirect action known as a derivative action. So this is really important because many times plaintiffs who are entitled to relief for loss of money, either through a breach of contract involving a corporation or primarily loss of their investment in the company, need to sue to get some kind of recovery. The problem is, if you don't sue properly, then you could end up getting your case dismissed and then be responsible for the defendant's attorney's fees and costs. You want to avoid that. So let's take a look. With direct actions, you are entitled to everything that you can prove. You get a judgment for $100,000, for example, you're entitled to $100,000. With a derivative action, however, that same $100,000 judgment against the company is going to be divided according to the ownership interest that you and the others have. So if you have 5 members of an LLC, for example, and you get that $100,000 judgment, and each of you own 20%, you're only going to collect $20,000. You might think that's unfair, that you put in $100,000 of your hard-earned money to invest in this company and to work in it, and someone just made off with the funds, misappropriated it, and you should be entitled to the $100,000 in total, but you are not. The big picture is because you gave that money to the company. It was the company's money. So the company was injured and you are suing for the company's loss, for the company's harm. So there are 2 elements you need to satisfy if you want to bring a direct action. The first one is that you are directly harmed from an injury that did not first flow to the company and that you had special damages. Or you have a completely separate duty that was owed to you that was breached that caused your damages. So that's how you have a direct action. Well, let's take a look at what that means. Harm not flowing to the company means that it is not something that everyone suffered. It's not something that the company suffered, such as one particular shareholder misappropriating assets that belong to the company. Okay, so that's number one. It cannot be something that is an injury to the company for which you're suing. And then part of that also is that you have to have a special injury yourself. A special injury is one where you're owed separate duties apart from the other shareholders and apart from the other members in the case of a limited liability company. This could be the right to vote. This could be other special profits or a different level of return that you're entitled to that no one else is entitled to. So these are the kinds of things that would be a special injury to you. The other way you can bring a direct action is if a separate duty was owed to you and it was breached. So this gets a little bit tricky, and this area of law is in constant flux depending on the facts and circumstances of each case that is looked at. But a separate duty can be an agreement in the operating agreement in the case of an LLC where all the members agree that they are responsible to each other individually for breaches of the operating agreement. So now let's also take a look at what a direct action is not comprised of. Fraud, intentional misappropriation of company assets, bad business decisions of your fellow members or of the president of the corporation who's also the majority shareholder. It's hard to believe, but those are not direct harms to you. You sure feel it because you lost your investment, but unfortunately you're going to have to bring that derivatively on behalf of the corporation or LLC, and you will have to share the damages that you can prove with everyone else in proportion to their ownership interests. So something to really be careful with, something to consider very carefully with your attorney well ahead of time before filing. So to review, a direct action needs to arise from a harm not flowing from the company combined with a special injury to you, or it needs to arise from a separate duty that was owed to you. Otherwise, if it's simply the loss of your investment without anything more, you're going to have to bring a derivative action. For more information, feel free to reach out to me through my website, eco-law.com, eco-law.com. Nicholas Economides, Florida attorney. Thank you for watching.